you get ready in the dark or something? 'Cause you look like a beautiful nightmare. Don't you know?
Welcome to this channel. Hope you all are doing great. In this episode, we'll discuss a new concept, euthanasia. Euthanasia is a combination of two Greek words, eu and thanatos. Eu mean well and thanatos mean death. Euthanasia mean easy death. The idea behind the concept is in place of painful and slow suffering to death, the patient to have a painless and quick death in exceptional circumstances. The practice of euthanasia can be traced back in the ancient Greece and Rome, where hemlock was used to cause death. The concept got support of Socrates and Plato, and vehemently opposed by Hippocrates. In the modern history, the concept got support from the English philosopher Francis Bacon in the 16th century. The thought of Francis Bacon got support of Karl Marx. Marx viewed that it is the duty of the doctor to ease the suffering of death using medicine. But in almost all the major religions around the globe opposed the practice of euthanasia. Religion viewed always the practice of euthanasia as the act against the will of God and nature. Samuel Williams was the first person who proposed the use of anesthetics and morphine to end the life of the patient intentionally in 1870. Thereafter, the debate arose in US and UK. Netherlands was the first country to legalize the euthanasia in 2001, followed by Belgium in 2002. Oregon in US was the first state which decriminalized the medical supported suicide, and the Supreme Court of South Korea was the first court which recognized the right to die with dignity in 2009. Euthanasia can be classified in three heads: 1. Voluntary euthanasia, 2. Non-voluntary euthanasia, and 3. Involuntary euthanasia. In voluntary euthanasia, it is conducted with the consent of the patient. Assisted suicide is legal in countries like Switzerland and some states in America. In non-voluntary euthanasia, it is done when the consent of the patient is not possible to obtain. Non-voluntary euthanasia is not legal in most of the countries, but passive form of non-voluntary euthanasia is legally recognized. And in voluntary euthanasia, it is done against the will of the patient. On the basis of method, the euthanasia again can be classified in two heads: 1. Passive euthanasia and 2. Active euthanasia. Passive mode is withholding or withdrawing or taking off the life support of terminally ill patient in vegetative state, while the active euthanasia is the participation of medical dosage. Is euthanasia is legal in India? To understand this concept, we have to take two words: suicide and assisted suicide. Suicide is a deliberate attempt to take away life of oneself. Indian Penal Code prescribes punishment for the same, but euthanasia is applied in case of terminally ill patient in a vegetative state, and assisted suicide is one in which another person knowingly assisting or helping in committing suicide. The question of legality of euthanasia is a heated debate in the legal arena. Article 21 of the Constitution of India envisages the right to life and personal liberty, and in the Maneka Gandhi versus Union of India case, the apex court goes ahead and said citizens' right to life and personal liberty be with dignity. The question is always in the legal room: right to life and right to die is separate or not. In 1987, Maruti Sripati Dubbal versus the state of Maharashtra, the Honorable Bombay High Court held that Section 309 of the Indian Penal Code is ultra-virus to the Constitution as it violated the Article 14 and 19 of the Constitution. Right to die is included with the right to life in Article 21 of the Constitution. In Rathinan versus Union of India in 1994, upheld the decision of 1987 case of M.S. Dubbal. But the twist came in the case of Gyan Kaur versus the state of Punjab in 1996, when the Supreme Court opined that Article 21 of the Constitution does not include the right to die. In 2011, in the case of Aruna Ramchandra Sanwag, Aruna was the staff nurse of the King Edward Memorial Hospital in Mumbai, and she suffered from the brainstem injury along with cervical cord injury and gone to the permanent vegetative state for 36 long years. In 2011, the three-bench judge of the Supreme Court drawn the difference between the active and passive euthanasia and further allowed the passive euthanasia under exceptional circumstances. The storm came again in 2018 in the case of the Common Cause versus the Union of India. The bench headed by the then Chief Justice of India Deepak Misra in their judgment flown the contention that the right to life with dignity includes the right to refuse treatment and die with dignity. Living will. With the concept of passive euthanasia, the term living will comes into play. Living will is a declaration or direction by a person during the treatment allowing to withdraw the medical treatment or support if such circumstances arises and authorizes a close person or relative to withdraw the medical support. If there is no such direction or living will, the hospital will inform the family members informing the actual condition and CMO and collector of the district. A board committee will be formed headed by the chief medical officer and furnishes the report to the judicial magistrate of first class. If remain any disagreement, then in such cases the matter will be referred to the High Court for withdrawing the life support. The only truth that comes with life is death. As soon the life comes on this earth, death becomes obvious. Man in a society always strives for dignified life, so wants a dignified death. Right to die, painless and with dignity, is man's inherent right. With the advancement of the age, the shape and function of the human body changes and also absorbs various illness of the organ. So, in case of the exceptional situation, such right to die, become inevitable with dignity, and man want to leave this earth with a smile.